rig, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. Rise up now, it's our time to shine. United and free. We'll write a new paradigm, new paradigm. United and free. United and free. United and free.
Ladies and gentlemen, may I have your attention, please? The show starts in 10, 9, 8, 7, 6, 5, 4, 3, 2, 1, go.
Arrested for a deadly hit-and-run crash, found guilty today of first-degree reckless homicide. That crash happened last November at 100th and Capitol. It killed Erin Mogensen, who was pregnant. Ben Jordan's reported extensively on reckless driving. He was in court today when the judge read the verdict. Ben, what are we hearing from Erin's family?
Steve, I've been in touch with Erin's family for the past year. I know how much today's verdict means to them. Well, they decided not to talk on camera today as they process their emotions. Erin's mom tells me this is the first step toward justice.
We, the jury, find the defendant, Frank Mosley, guilty of first-degree reckless homicide.
Frank Mosley didn't show any emotion as the guilty verdict was read. This morning in court, we saw dash camera footage of the police chase that led up to the crash. Mosley reached speeds of 116 miles an hour when the Wauwatosa officer called off the pursuit.
He's doing that quickly. He's going to blow the red light at 100th and then terminate.
Seconds later, Mosley ran a red light at 100th and Capitol, killing Erin and her unborn child on impact. Surveillance video captured Mosley running away from the scene. He was later arrested by police. All it took was 2 hours of deliberating for the jury to find Mosley guilty on all counts.
The court enters judgment on the verdicts for the state as to each of counts 1, 2, 3, and 4.
I've been in touch with Aaron's family for months as they advocate for change. I told their stories as they fought for new legislation and harsher punishments for drivers who flee police and cause death or serious harm. Aaron's family was at the Capitol when it was signed into law. And most recently, I've done stories on Aaron's mom as she launches a new court watch program in Milwaukee County to monitor reckless driving sentences. Ruth Ergot wants everyone to remember Aaron's name and her legacy. Here's what she told me a couple months ago.
It was so unnecessary. It was so unnecessary. He was going so fast, she was simply sitting to turn left. So in no way did she have any involvement. But that's the devastating part. It's the part that I don't know how we get over that compounded with Aaron.
Mosley is set to be sentenced in November. He could face more than 100 years behind bars. Reporting live at the Milwaukee County Courthouse, Ben Jordan, TMJ4 News.
Okay, I think we're ready to get started. Madam Clerk.
State of Wisconsin versus Frank Mosley, 23 CF 5099 appearances.
Michael Lonsky on behalf of the state. I'm here with Milwaukee Police Officer Richard Schneer.
Mr. Payne.
Attorney Karan Payne, who appears on behalf of Mr. Mosley, who appears in person. Good afternoon, everyone.
Good afternoon, everyone. We're all in court today for a sentencing hearing, and I understand the parties are ready to proceed. Both parties have filed a number of documents with the court. The state has filed a group of victim witness impact statements, and I've read all those statements from family members and loved ones of the victim here. The defense has also filed this afternoon a sentencing memorandum authored by Mr. Payne, and also letters from family members and friends of the defendant, Mr. Mosley. Okay, phones are not permitted in the courtroom. Okay, there is an absolute no appeal prohibition on phone use in this courtroom. The only people who will be exempted from that rule are people who are speaking on behalf of either the state or the defense, and only while they are speaking. If there is any phone observed in this courtroom in use by anyone, that person will be immediately removed from the courtroom and will not be permitted to return for the duration of the hearing. I just want to make that clear. Law enforcement personnel are all going to be enforcing that rule while we're in session. Right. We do have a very full gallery. A lot of individuals are planning to speak today. And I'm just going to ask everyone, you might hear things you don't agree with. The fact that you don't agree with something you hear is not going to have any impact on me. Unfortunately, I've been entrusted with making the decision today in terms of the sentence. And I'll hear all of the statements that are going to be made, and at the end of the hearing, the court will make a ruling. And I just want everyone to be respectful of each other in this court as that process continues. So again, the parties have filed a number of documents with the court. I've reviewed those documents. I believe everyone's ready to proceed. A pre-sentence investigation report has been filed. I've reviewed that report. Parties, did you receive it and review it, Mr. Lonsky?
Yes.
Okay, any requests for changes?
No.
Okay, Mr. Payne?
Yes, Judge, we've reviewed it. No request for changes.
Okay, all right, and again, that report is on file with the court. It does include the Department of Corrections recommendation as to a sentence in this case, And that's one of the recommendations I'll be taking into account when reaching a decision at the close of the hearing. So otherwise, parties, are you ready to proceed? Mr. Lonsky?
Yes.
Okay, Mr. Payne?
Yes, Judge.
Okay. And Mr. Mosley, I have to ask you this question directly as well. Sir, are you ready to proceed today?
Yes, sure, man.
Okay. All right. So I'm going to go back to the state. Mr. Lansky, has the state complied with victim notification requirements?
Yes.
Okay. All right. And again, a number of statements are on file with the court, including a restitution claim. I think it makes sense to address that first. Mr. Lansky, regarding that restitution claim?
Yes, we did send an itemized statement, filed it with CCAP, and it totals $12,599.81. It's all payable to the victim's husband, Alexander Mogensen, and it's for a auto insurance deductible and funeral expenses.
All right. And Mr. Payne?
Judge, defense stipulates to restitution.
All right. And I agree those amounts all are subject to restitution under state law. So the court does grant restitution here in the amount of $12,599.81 as set forth in that restitution claim that's payable here to Mr. Mogensen, the victim's husband. All right. All right. Then we'll continue with the state. Mr. Lansky?
There should be 4 speakers. Do we have the, who's first? It looks like Sarah Drew.
All right, ma'am, if you could please state your name and spell it for the record.
Sarah Drew, S-A-R-A-H-D-R-E-W.
Thank you, Ms. Drew. Whatever you want to say, go ahead.
All right. On November 2nd, 2023, I received a phone call that I never thought I would have to endure. A phone call that would change my life and the lives of my family forever. That's the day that I learned that I would never see my sister again. Never have another phone call, another arts and crafts day, another Christmas cookie making day. That day, I didn't just lose my sister, I lost my best friend. My children lost their aunt, who was an integral part of their lives. Erin has been in my life since I was 7. For 32 years, she was my best friend, the thorn in my side, the one who I joked with, and the one that I planned with. I still wake up daily thinking about something that I would love to talk to her about, a movie or a musical coming out that I know she would love, and the pain that I will forever endure knowing that I've lost my person. The thought that has been a focal point of countless nightmares is the fact that Erin and her unborn baby were left to die in the street alone, left for dead by the man who chose the opportunity to try to flee the consequences of his own decisions instead of even checking on her. I have never felt more helpless in my whole life, knowing that I was an hour and a half away from her, trying so hard to get to her as fast as I could, even though I knew that she was already gone. How can someone be driving 116 miles an hour, running red lights, and failing to even stop for a marked officer be considered an accident? I have asked myself this question over and over again. I have talked about this with my family, my son, my therapist, and every conversation has led to the same conclusion. It wasn't an accident. It was a series of selfish, careless, reckless choices, and the people that paid the ultimate price for those choices were my beautiful sister and niece or nephew. What started out as a normal day, texting her about our upcoming vacation less than 45 minutes before her death, instantly turned into the worst day of my life. Having to face the world and gather our children only to have to break the news that their Aunt Erin, the aunt that played with them and loved them, was not only dead, but violently killed. Mourning the loss of my children's innocence and their sense of safety. It will forever haunt me the day that my 4-year-old daughter first asked me if bad guys were going to come and kill me and her too. Erin was not in the wrong place at the wrong time. She was living her best life, excited for what the future held for her and her growing family. It pains me that I have to sit here today reading this instead of experiencing Erin's child's first snow. She always made sure to include family in all of life's moments, regardless of how big or small, even if they weren't physically there. I miss those texts more than words can express. That day didn't just take 2 lives. That day destroyed families. Families that will never be the same again without her. And I implore the court to sentence appropriately so that other families may never have to be put through the nightmare that we have had to endure, the pain that will never go away. Thank you very much.
Thank you very much, ma'am. Next speaker.
This is Mark Hagen, Hagen.
Thank you. Sir, go ahead, please. Thank you.
Last November 4th, my 12-year-old grandson and I were sitting at my computer. We were ordering a dog tape with his Aunt Erin's fingerprint on it because he wanted something tangible to wear to her funeral the next weekend. He asked me whether it was true that Aunt Erin's killer was really going 116 miles an hour. When I told him yes, he asked, then why are people calling it an accident? Everyone knows you're going to kill someone going that fast in her neighborhood. You have undoubtedly read many victim impact statements submitted to you by people describing the incredible and amazing woman Erin is. But to me, she was, is, and always will be my precious little girl. If my precious daughter died of disease, a natural disaster, or even a traffic accident, we would be well into the grieving process by now. But Erin was not killed accidentally, but rather due to a series of deliberate, intentional, and criminal decisions made by one person. Even a 12-year-old knows she did not die as a result of an accident. Since Erin's homicide, I have yet to get through a day without breaking down or able to sleep more than 3 hours at a time due to the intense anger, grief, and nightmares I've experienced. Every time I feel a bit of joy, I reach for my phone to text Erin and Sarah to share that joy like I've always done. Forgetting for a moment that Erin is gone. When that realization hits, my wounds are ripped wide open and she's murdered all over again. I could talk for hours about my pain, but I'm probably one of the luckier ones in Erin's family. I was blessed to spend the most time with her and statistically the most likely to be the next person to die, sparing me many years of grief and pain, facing all other members of Erin's circle. And how pathetic Milwaukee has become, dystopia with many residents preferring death over the intense grief that we have been forced on us by criminals like the one who took Erin's life. But my grief and anger pale in comparison to the most obvious victims. My precious little girl and my grandchild. As a father, my selfish goals and aspirations disappeared the day my daughters were born. Their dreams became my dreams. The only thing I wanted out of my life was for them to achieve their hopes, dreams, and aspirations. Erin's dreams were modest. She didn't give a damn about wealth, fame, or narcissistic TikTok or Instagram followers. Her dream was a husband she could love and trust, and a family they could raise together in a warm, safe, and nurturing home. She found an amazing man who showered her with love and devotion. They found a community in which to raise a family. And she finally learned she was about to become a mother. All her dreams were about to come true until her path crossed with evil. My grandchild had the most amazing future ripped from them. That child would have been loved like no other by two amazing parents. That child would have been raised to be respectful, law-abiding, and moral and ethically strong, attributes that could never be attributed to her murderer. And above all, that child would have been happy and joyous, would have been unconditionally loved and undoubtedly spoiled by all in her family. Erin's childhood was not easy, and she was forced to deal with many family challenges, none of her own doing. However, she did not use those challenges as an excuse to lie, steal, and kill. She rose above them to lead an exemplary life. She chose to break cycles, forgive those who hurt her, and spread love and joy. No father could be more proud of a child than I am of Erin. Erin was selfless. Erin was a person that everyone in her family leaned on for everything they needed done. If there was an event to be planned and catered, housework that needed to be done, or errands or rides that someone needed, it was always Erin who was expected to step up, and she always did. Although the demands put upon her created significant mental and physical stress, she never said no. Shortly before her homicide, she promised me that she would finally live her life and put herself first by learning to say no. She, of course, amended it to that she would put her baby, Alex, and herself first. It's the only promise to me that she ever made that she failed to keep, due, of course, to her violent and premature death. Erin contributed to the community. She didn't terrorize it. She volunteered at the Milwaukee County Zoo, and quite naturally to all who know her, spent most of her time educating young visitors through the zoo's educational wing. Erin was disgusted by the threats of violence directed to poll workers in our community, so she became one herself and was studying to become a poll captain before she was killed. She cared about justice and making her community a better place. She added to her community. She didn't exploit it. She marched for social causes and urged family members, myself included, to join her. That dedication to justice lives on through Enough is Enough, a legacy for Erin, a group founded by friends and family to honor her and the countless others who have been injured or killed by criminal reckless driving, and to address the lack of accountability in addressing this epidemic. Erin's spirit lives on through the amazing and dedicated members of this group. Above all, Erin was bringing life into this world, not destroying it. A major contributing factor to my grief and pain is the way Erin died and the complete lack of accountability and responsibility demonstrated by her killer. To hit a human being at 70 miles an hour and not once stop to see if you could save their life, but rather gather evidence and flee like a coward demonstrates such a depraved indifference to human life and is so evil that that person is beyond redemption. Make no mistake, nobody fled in panic, as a collection of evidence demonstrated. His defense even made a repeated point of showing how he turned around and took a step toward the crash. That brief video is one of the most damning pieces of evidence, and it's caused me almost daily nightmares. He turned around and saw the carnage he created, and he saw that no one was getting out of that car. Yet instead of running to see if he could do anything to spare a life, an action that any human being with a conscience would take, he simply ran away and left Erin to die. A stray dog would have demonstrated more empathy for my innocent little girl that day than the criminal who destroyed her life and ours. The actions of her killer haunt me every moment of every day of my life. More than one person has shared the idea that Erin was simply an innocent victim who was in the wrong place at the wrong time. That observation adds to my pain and the pain of Erin's family. I agree with Jeannie Lupo, president of Enough is Enough, who quickly and empathetically shot down that notion when she argued no, he was in the wrong place at the wrong time. My daughter was innocently going about her business, preparing for her wedding anniversary that very day, and our family trip to Disney World we would be taking 2 days later. Her killer should have been in jail. He was in the wrong place. Several people have sent me TikTok videos of Erin's killer waving and flashing guns, behavior that was inferred as artistic, asking if this was the coward who took Erin's life. Imagine our anger and disgust when we read on several occasions he was warned that such behavior, even if the guns were toys or props, were violation of his terms of release. This is just one painful example of many that are too numerous to mention of this individual's beliefs that society rules and norms simply don't apply to him. Erin and her family, myself included of course, have been further victimized by these court proceedings. The constant disrespect shown to Your Honor and to this court throughout this trial naturally extends to the memory of my innocent daughter. Between her killer laughing, waving, and allowing his picture to be taken during the sidebars, to his attorney making the suggestion in his opening remark to the jury that they might, and I quote, maybe even have some fun. Maybe even have some fun, despite the fact that he was well aware that those same jury members would be watching graphic video of Erin's violent and horrific final moments on earth. I assure you nothing has been fun in the years since Erin was violently taken from us. We were mocked and ridiculed for showing emotion during the horrific videos that were shown. Yet those same people who laughed at us for our tears were brought to tears when the jury reached their decision. The callousness and cruelty directed at my daughter in this room exacerbated an already numbing grief and pain, and has turned my grief and anger into intense hatred towards her killer and the many who enabled it. I am not seeking justice for Erin today. That's not possible. I do ask, however, for justice for my daughter Sarah, my grandchildren, my son-in-law Alex, and Alex's family and all innocent members of this community. I beg you to keep Erin's killer incarcerated so law-abiding families and innocent members of this community aren't further harmed by this criminal. And make no mistake, he is an extreme danger to society. He has demonstrated beyond dispute that his narcissism and selfishness puts our community in danger by his willingness to take any action necessary, including now a double homicide, to escape all responsibility and accountability for his behavior. I respectfully ask you to impose a maximum sentence on all 4 felony counts. To sentence this felon to concurrent sentencing sends a very clear and loud message to Erin, Alex, and their family that their child meant nothing and innocent life isn't valued in Milwaukee County. And a concurrent sentence would send a clear message to Wauwatosa Police Officer Brian Wade and other police officers, as well as first responder Andrea Conway, that the Milwaukee County court system devalues their service and efforts to keep our community safe and accepts the anarchy that we are currently experiencing on our streets and in our community. Officer Wade, one of the few public servants who had the strength to talk to me directly about the events of that day, is suffering like the rest of the innocent victims of this crime. Ms. Conway, the first responder who tried desperately to save Erin's life that morning, took time out of her weekend to attend Erin's funeral. I remember very little about my daughter's funeral other than Ms. Conway, unable to say anything to me other than she was so sorry she couldn't do more to save Erin's life. Officer Wade and first responder Conway are victims, suffering not because of anything they did, but by the decisions and actions of the person who took my precious daughter's life. In closing, I respectfully ask you to demonstrate the same courage and strength that 12 ordinary citizens demonstrated when they handed down their verdict by holding this killer accountable to the maximum extent allowed by law. Thank you, Your Honor.
Thank you, sir. Our next speaker, please.
All right, this is Ruth Ergot. Pronounce it right? That's E-H-R-G-O-T-T.
Thank you, ma'am. Go ahead.
Good morning. I am the mother of Erin Mogensen and the grandmother of my unborn grandchild, baby M. I come before you today carrying a burden that Words cannot fully capture the weight of profound and unrelenting grief for the loss of 2 lives that meant everything to me. The pain of losing my youngest daughter and grandchild is a wound that will never heal, a constant ache that has hollowed out my heart and darkened so many days that should have been filled with joy. Erin was a beautiful light in our family and community, a loving and compassionate young woman with dreams that reached far beyond her years. Baby M, our beautiful grandchild, was supposed to grow up surrounded by love, experiencing life's firsts, first steps, first holidays, first moments that are meant to be celebrated with laughter and pride. We would have had a first snowfall today, and instead we've been left with silent, empty spaces, milestones that will forever remain unfulfilled. Every holiday, every family gathering is now a reminder of what should have been. The laughter we long to hear has been replaced with quiet tears. Your Honor, the defendant's actions did not arise from a momentary lapse of judgment or an accident. His choices were deliberate and callous, reflecting a reckless disregard for the value of human life. He shattered our family, our dreams, and our future in one senseless act. And what makes this reality even more unbearable is the absence of any genuine remorse or acknowledgement from him. How does he look at the devastation left behind and fail to comprehend the enormity of the pain that he's inflicted? I strive every day to work towards forgiveness because I know that carrying this anger and sorrow forever will only break me further. But forgiveness does not mean forgetting or excusing. It does not change the weight of the loss that we've suffered. It does not replace the irreplaceable or mend the fractures in our hearts. And it certainly does not absolve the defendant from the need for accountability. He needs to be removed from society for a long time, so that no other family has to experience the level of pain and devastation, and so that innocent lives are no longer put at risk by his actions. True justice demands that we honor both Erin's and Baby M's lives, recognizing them as 2 separate and beautiful souls that they were. The punishment must reflect this truth and the magnitude of what has been taken from us. Therefore, consecutive sentences are the only way to affirm the value of 2 lives lost. Your Honor, while there is no sentence that could ever bring them back or restore what has been lost, we need this court to send a clear message that reckless, selfish choices have irreversible consequences, and that the lives stolen from us mattered deeply. We will never be whole again, but we hope that justice will be served, and that somehow, amidst this unimaginable pain, we might find some semblance of peace. I will continue to honor Erin and Baby M, carrying their light in my heart, and I will strive to live a life that would make them proud, holding on to the hope that we will be reunited one day. But until then, I carry their memories, and please, I fight for the justice that they deserve. Thank you.
Thank you, ma'am.
This is Alex Mogensen. The loss of Aaron, my wife, my best friend, my partner, the love of my life, and the mother of my child has devastated me. Not only has this person taken Aaron from me, our family, and the community, he stole our unborn child and the future that we had planned, and we're honestly still planning for us and our new family. I understand that whatever decision is made today in court will not bring Aaron or my child back. But maybe we can save the life of others that this person would also destroy carelessly. I ask the court to give the maximum of each charge served consecutively with no chance of parole or opportunity to serve at home. This person at every point of this has tried to avoid responsibility by either running or denying. In my opinion, if this person were ever to leave custody, he would run again, likely putting more people in danger. And that is all.
Thank you. Thank you, sir. All right, thanks for all the speakers. I'm very sorry for your losses. We're going to go back to Mr. Lonsky.
Those are the speakers. Judge, you heard the trial in the case. I'm just going to very briefly go over the evidence. It started with the squad camera and the body camera of the Wauwatosa police officer who sees the BMW SUV, sees that it has no plates, gets behind it to stop it, and lights it up, and it speeds up. Goes so fast that it gains several blocks distance on the squad, who wisely abandons the chase, given that no plates is not a serious enough infraction to endanger the community over. And the car continues speeding, runs a red light, and T-bones the victim. Immediately he gets out of the car, he runs through the gas station parking lot. There's a video of him doing that. He ends up getting caught at a 39th Street address. At that address, there is the key fob that works the car. There's some paperwork that's being burned in a grill in the backyard, along with what appears to be a hoodie. The neighbor who lives there happened that morning to take a photograph of the car before the accident, because it had parked so close to her car that it was obstructing her, or something like that. And also within that car there was a receipt. Within the crashed car there was the Walmart receipt that was traced back to the Walmart videos that showed a person who was obviously the defendant. There were tattoos on his hands. There was a hoodie consistent with, was that left in the car? Yeah. There was the hoodie. On one of his hands there was a blemish. It was just obviously him in the Walmart video. When he was arrested, he, I should note, the owner of the car that he was driving reported it stolen. And reported it about a week before, the day after. He said that it was stolen at night, and I think the owner came to the police in the morning and reported stolen. I'm not sure really if it was stolen or not. The defendant, when he was arrested, the defendant admitted getting the car from the owner, but he said it wasn't stolen, it was lent to him, and he had it stolen from him. Then he basically distanced himself from the car, saying, yeah, I had the car once, and then somebody else stole it from me, and that happened before Walmart. He denied that it was him on the Walmart video or driving it down the day of the crime. I didn't use that statement at trial. I kind of kept it in my back pocket if he would testify. The evidence that I did present was so strong I didn't think I needed it. But it was would have been pretty damaging if I put it in, because it was basically him sitting there denying that the Walmart person was him when it was so overwhelmingly obvious that it was him, given the tattoos and the blemishes and all the other things you could see on the video. So it would have made him look like a bald-faced liar. That was the evidence at trial that I used, and some of it that I chose not to. This is a very egregious and serious crime. Here we got 2 deaths involved. There have been plenty of, it's sad to say, but there have been plenty of fatal accidents in Milwaukee recently. And a lot of those have been charged as second-degree reckless homicide, because the one element that distinguishes first degree from second degree is utter disregard for human life. This one was charged as first degree, and the jury agreed with that assessment of the defendant having shown utter disregard for human life. He did that in a lot of ways, simply going 116 miles an hour at one point. The reason for doing it was to escape the police, whether he was afraid they were he was in trouble for the car that for some reason he had removed the plates from, or some other thing he had in the car that he didn't want the police to find out about. Who knows? But he whatever he wants to get away for, he goes 116 miles an hour up Capitol Drive. He slows down for a red light, but he's going so fast to begin with that the best he can do is get down into the 70s, which is devastating speed to T-bone somebody going 70 miles an hour. That was the best he could do by hitting the brakes, is get all the way, get it down to 70. Then how does he react? He reacts by running from the scene, leaving the devastation behind, not seeing who he had hit, and whether he could help, whether he could save a life or more than one life. He didn't know how many people were in that car. And then he tries to destroy the evidence. And when police confront him about it and question him about it, he lies. I was surprised to see in the pre-sentence that he does now say that he did this. He admits it, and he is being remorseful. It's always hard for me to judge sincerity. I'll leave that to the court. It could be very well that he is apologetic, or it could simply be that he's smart enough to know that he might come out with a better sentence if he presents himself as apologetic. So I'll leave it to the court, but I do note that he does admit what he did and acknowledges the wrongfulness of that. The community is fed up with this kind of crime. I mean, this case prompted people to get together and form this group that's been coming to various traffic cases in court. They're just fed up with it. And rightfully so. A lot of people live their lives to avoid the dramas that the court system sees every day. Most in these homicide courts, a lot of these homicides happen because the victims, for one reason or another, get involved in situations that are risky. Whether it's a fight in a tavern, whether it's a drug deal in an alley, whether it's they're trading guns, stolen guns, or whatever. The people are involved in these situations that put them at risk. But with these traffic things, it's just ordinary people who are avoiding the drama, avoiding crime. They have nothing to do with it. They're just innocent people going about their lives And here we are, you know, people like you and me driving home from work tonight, just going about our lives, and we're at risk of getting killed. People are sick and tired of that, and it's become a big problem in Milwaukee. The defendants, I looked at his character, take it into account when making a recommendation, and there's good things about it. I mean, he finished high school. You don't see a lot of that in the homicides court. Looks like he had better than average grades, we'll call it that. He had some behavioral trouble in high school, but he finished. I give him a lot of credit for that. His criminal history, it's chronic. It doesn't stop. Getting probation for it doesn't seem to stop it, but it's all retail theft. He basically presents as a thief, not as a violent criminal. So he doesn't come here with a clean record. He comes here with I'll call it a relatively lengthy record, but it's all the same type of crime, retail theft. So where does that leave me as far as a recommendation? I understand exactly where the family is coming from, wanting this whole, all these charges to be maxed out consecutively. I looked at what the pre-sentence writer wrote, and this was an unusual situation for me, where when I read what the pre-sentence writer, the writer was pretty much in the same area as I added up. She's asking on each count for the writer is asking on each count for there to be a consecutive sentence. On counts 1 and 2, asking for the range of initial confinement of 16 to 20 years. On counts 3 and 4, asking for the initial confinement to be between 4 and 5 years. You add that up, and the writer is recommending between 40 and 50 years of initial confinement. And when I added up the consecutive extended supervision, that would be 20 to 28 years of that. I agree with the number 40 for the initial confinement. Whether the court, how the court gets there between all the counts is really an academic matter, almost in my view. I think there should be consecutive counts for the two lives that were taken. But I think 40 years is an appropriate amount of initial confinement. That's what I'm going to ask the court to impose.
Thank you. All right, so that is the state's argument.
Yes.
Thank you, sir. I'm going to move now to the defense. Mr. Payne.
Judge, we have one person who would like to speak, or Mr. Mosley.
Okay. Sir, if you could please start by stating your name and spelling it for the record.
My name is Frank Mosley, III. M-O-S-L-E-Y.
Thank you, sir.
First and foremost, I would like to send my deepest condolences to the victims and the victims' family. My son made a split-second decision that changed the lives of many in ways you couldn't imagine.
Can we pull the mic closer, please? It's a little hard to hear you, sir. Thanks.
First and foremost, I would like to send my deepest condolences to the victims and the victims' family. My son made a split-second decision that changed the life of many people in many ways that we couldn't imagine. I know the victims' families, as well as our own family, is dealing with the consequences of my son's actions. My son recently graduated from Milwaukee School of Arts with a slightly above average grade point. You know, it wasn't the greatest, but it made us proud. My son was a young man coming of age that made an irrational, impulsive decision that changed the course of life, of his life and ours as well. And, you know, I know some mistakes can be taken back, but some can't, especially when a life has been taken. No matter how great or how far the apology, it can never replace what has been taken. My son is a young man. He's a compassionate person who made a life-altering decision that's going to cost everyone involved dearly. I hope the court can see past his mistakes and give my son an opportunity to become a positive and productive member of society after his sentence. I know my son is truly remorseful and heartbroken over the situation. I hope the court can be fair and lenient. Once again, I would like to send my deepest condolences to the victims and the victims' family, and I pray that everyone involved find peace and forgiveness in their heart.
Thank you, sir. Thanks for your statement today. We have one additional speaker. Hi, ma'am. Yes, please pull the mic. Just you can raise the mic and just pull it a little closer. And
okay, I just want to give my
your name for the record, please.
Jaleesa Gomez. I'm Frank's big sister.
Okay.
Yeah.
Yeah.
JALISA GUMBUS.
Thank you, ma'am.
Okay. Came up here to say, brother, he's definitely not who everyone thinks that he is, or painting him out to be. He's not a monster. He's not none of that. He made one mistake, one mistake. My brother has made me the proudest big sister ever. He graduated high school. He went to college. He made me proud with his music. He don't talk about drug dealing or stealing cars and none of that. You know what I mean? And it hurts me more because, I understand that you guys are hurting. And I understand the situation. I understand all mistakes or all things, it comes with consequences. I understand that. But he's just not that person. He's not a menace to society that everyone thinks. He just made a mistake. I'm just asking to please just take that in consideration with that. Please. He's very creative. Like, he's outstanding, outgoing. Like, his mind is up here to the world. Like, he's not who everybody made him out to be. And I wanted to talk because I wanted everybody to know who he was, not who everybody think he is. That's all I gotta say.
Thank you, Miss. Okay, this will be our last speaker for the defense. Ma'am, if you could please have a seat. State and spell your name for the record.
Hi, my name is Bobby Neal, and I'm Frank's auntie.
Okay, could you spell that, please?
BLBBIENEAL. I just want you guys to know that Frank has mental problems. He's always had them since he was a child, but we never got him assessed. So, if please, Your Honor, could you just send him to the mental ward so he can get his life together? Because if you send him to prison, it's still going to be the same thing. He's not going to address what's really going on with him. He's been like this all his life.
Okay, ma'am. Thank you for your statement today.
Okay.
Thanks for coming to court. Okay. Thank you, everyone, for your statements. I'm going to go back to Mr. Payne now.
Thank you, Judge. When I first met Mr. Mosley, he was nothing short of tremendously remorseful. The only thing that has ever been in contention here was the fact that Mr. Mosley believed that he did everything he could to slow that car down, to move out of the way, and that this was a car accident. When we went to trial, the defense did not lie to the jury. We did not mislead the jury in any way. We wanted, Frank Mosley specifically, wanted them to see that it was an accident. He pressed the brakes as hard as he could, we heard testimony. It broke the BMW system, how hard he pressed those brakes. He swerved around cars. And ultimately, he hit the victim here. As I said before, and I'll say again, she did nothing wrong. She was doing nothing wrong. This is 100% Frank Mosley's fault. But it's an accident, a tragic accident. I can listen to comments about myself, about defense's theories, but to paint Frank Mosley as a monster, as a person who did not care, is highly incorrect. He did care. He cared so much that he wrote letters to the family, to the victim, because that's what he wears every day as he's sitting in that cell. Judge, I'll read what Mr. Frank said to the PSI writer. I take responsibility for what happened that caused her death and the death of her unborn child. If I could, I would change places with her. I don't know her, but she didn't deserve this, and there's a special place in heaven for her. We have grown men, 30, 40 years old, who fight, cheat, lie, and steal to get a favorable sentence. Mr. Mosley didn't do that. We have those same men who never accept what's coming to them. Mr. Mosley is different. I submitted a PSI, or I submitted my sentencing memorandum to the court. We know he graduated, but we also know that he is what I would call a very talented music artist. This case has never been, let's say, low stakes. Let's say everyone has known about this case since it started. It's been a very big deal. There are communities across Wisconsin listening to this court, from the victim side and from the defense's side. After this trial, Running Rebels asked me to speak to the children there. And their question was, what do we do in the situation? I told them to just stop. Stop. If you are in a car, you have drugs in your pocket, just stop. You have license plates that have issues, or this car's not yours, just stop. Just stop, because the court will understand and will respect you for just stopping. You did not make a situation worse. And I believe that a message does need to be sent. But what should that message be? If you make a mistake and we catch you, we're going to send you away for 40 years? Is that the message we want to give them? I don't think so. I think we want this to stop. I want it to stop. How do we get that? We have to reach the youth. And 40 years is unfathomable to a 20-year-old, unfathomable to a 17-year-old, 15-year-old. They think their life is over when it's really not. Sit there, stay calm, and let this process play out, because you will be treated fairly. The courts will hear you. But if you run and you cause this travesty, the death of a very innocent young lady, you're going to have worse consequences. So, Judge, I'm asking for a sentence that penalizes and punishes Mr. Mosley for sure, but one that also allows him to live more life, as I believe that would be consistent. And I can continue on saying, stop. It will only get worse if you run. Your life will not be over. We will deal with it on the back end. Thank you.
Thank you, Mr. Payne. So I've heard from Mr. Payne, Mr. Mosley. This is your turn to speak. If you have a statement you want to read, that's fine. However you want to go forward. Go ahead, please.
Initially, I had a statement wrote that I wanted to say to the family, but I'm gonna just do this one from the heart. My deepest condolences goes to Aaron's family. And what happened on November 2nd, it wasn't meant to happen. People can feel how they want to feel about me, but I am who I am. My whole life, I've been a black sheep. I've been a person in the background, the person that don't really get picked much, the person that never really say too much, but I've always been the smartest in the room. I made a mistake, one that might cost me my life. But I want them to know that it wasn't premeditated. It wasn't something that I meant to do. It was a mistake. A mistake that I pay with every day. Every day I sit in that cell, I think about it. What I could have did different, what I didn't do right. 7 months before the crash, my other dad, which is my stepdad, committed suicide right in front of my eyes. And it changed me. I never would have hurt Aaron willingly. Never. I wouldn't even think about it. And I wish I could take it back, but I can't. So I talk to God about it every night. And I believe she do deserve a special place in heaven, because she didn't deserve that. Thank you.
Thank you. All right, that concludes all the statements from both parties then. I'm just going to take a couple of minutes off the record here. Can ask everyone to wait. It'll just be a couple of minutes and I'll explain the sentence in just a moment. back on the record. Again, parties, thank you for your statements today. I appreciate the statements of everyone who spoke. Obviously, feelings are very strong here. The victim's family has suffered a terrible loss, and Mr. Mosley is facing some very significant consequences for his actions. So, with any sentencing, we start with admonitions. These are parts of the sentence that are required by law. And Mr. Mosley, first, with these felony convictions, you may not possess a firearm at any time in the future. Section 941.29 of the statutes makes it another felony for anyone who has been convicted of a felony to ever possess a firearm, carrying with it its own 10-year period of imprisonment or $25,000 fine or both. Also, you cannot vote in any election until your civil rights are restored, and you are required to provide a DNA sample to the state crime lab and pay a DNA surcharge for each of these 4 counts. You are advised that if this conviction is reversed, set aside, or vacated, you may qualify to have that DNA sample data expunged if you meet other conditions under statute. Because the nature of the charges here, also you may not possess body armor at any time in the future. Section 941.291 of the statutes makes it another felony for anyone who has been convicted of counts 1 and 2 to ever possess body armor, carrying with it its own 15-year period of imprisonment or $50,000 fine or both. So in determining a sentence, the court looks at certain factors, and these are determined by our state law. They are also addressed by the parties in their sentencing memoranda and in the pre-sentence investigation. We start with the gravity of the offense. And here, this offense is almost at the highest possible level. The only higher level offense would be an intentional homicide. And here, this was not intentional. And I think everyone agrees, Mr. Mosley, that you did not set out that day to kill someone, including Ms. Mogensen or her child. But that was the natural effect of your actions. And you did take her life. You took the life of her child as well. And her family is now serving a life sentence of never having her or her child in their lives. And that's why this is a Class B felony. The only higher level is a Class A felony. Again, that would be an intentional homicide. But if you take someone's life in circumstances that for this type of offense indicate an utter disregard for human life, that's what puts you in the position you're in today, which is facing a very significant sentence. It's not in this court's capacity to weigh the value of a human life. Unfortunately, that's the only way the court can enforce the law, is to come up with a number. And frankly, it's disrespectful to Mrs. Mogensen and her child to assign a number to the value of her life and the value that it had to this community. But that's the only role the court can play. Nothing I say or order today is going to make this case any easier for anyone. It is only going to bring an end to the legal proceedings, at least here at the circuit court level. But that's why we're at the point we're at. You took 2 lives, and there are significant consequences that flow from that, from your decisions that you made that day. When I next look at your character and rehabilitative needs, now here, the only expressions of remorse I've heard from you were actually today. And even today, to be honest, in your statement, you've talked mainly about yourself. I heard very little about Erin or her child or the loss that her family has experienced. The letters from your loved ones are very persuasive, but what I have to focus on is your what appears to be a sort of beginnings of remorse and a very, what I would say, limited acceptance of responsibility, and then your rehabilitative needs. To describe this as an accident, I think is accurate only in that, again, you did not intend to take a life that day. But that's not where the law ends. You chose to drive a car at an absurdly high rate of speed through the city, a very densely populated part of the city, through red lights, and you caused this terrible accident and took 2 lives. There is no question here that you bear the responsibility for those deaths. even if you didn't set out to take lives that day, it was the natural outcome of your actions. If you hadn't hit Mrs. Mogensen, you likely would have hit someone else. So when I look at your character, what I see is a young man who is just beginning to grasp the gravity of these offenses, which tells me you have very, very significant rehabilitative needs. I agree with your aunt that you probably need some mental health treatment, but that will have to be engaged in custody. That brings me to our last factor, which is the need to protect the public, and that is the number one sentencing objective. When we talk about how our state law defines sentencing, we start with protection of the community. And this is a case where you have shown yourself to be a real danger to this community. You have a limited criminal record, but your criminal record begins as a juvenile and continues through young adulthood, right up to where we ended in November of last year with this terrible offense. You've been in custody since then. The fact that you were in contact with law enforcement on a regular basis and on probation, and that those probationary orders apparently were completely unsuccessful in redirecting your conduct, shows me again, very forcefully, that you have very, very significant rehabilitative needs. So when we talk about protection of the community, this community is absolutely outraged by cases of this type. It is not an exaggeration to say I've had a series of cases very much like yours, one after another, since I started in this rotation just over a year ago. And I've had so many, it's starting to get difficult for me to remember the facts of each case. Some stand out, yours stands out, because you took the life of a young woman who was about to become a mother. That is a tragedy of just almost incomprehensible gravity. Another case I can remember is a young woman about your age who took the lives of 5 members of her own family because she was driving recklessly at high speed through the city and crashed. I have another case, a young man, not much older than you, who took 2 lives in a crash and seriously injured other people in the same crash. Those are just the few I can remember off the top of my head, but there have been several others, unfortunately. And this community is absolutely outraged by these cases. I don't have an explanation for why reckless driving has grown so rapidly and so suddenly as a thing, but it is something people in this community have to deal with every day now. The city is installing speed bumps and traffic circles to try to slow cars down, and it is having some effect. But that's only on side streets. On the main roads, like the road you were on, that's a completely impractical solution. What we have to see is people slowing down. And that isn't going to happen until people who kill other people in crashes of this type go to prison. And hopefully that has a deterrent effect. And that is one of the objectives the court has to look at when I impose a sentence. We start with the protection of the community. Second, we look at your rehabilitation. Again, and your needs are extremely high. Last, we look at deterrence, how to deter you as well as others. And the court can only accomplish that deterrent effect by ordering significant sentences in cases of this type. So all of those factors and objectives taken together, and also the recommendations of the parties, the court comes up with what is the answer in this case. That is just an answer. It doesn't solve the problem. It doesn't even begin to solve the problem. And it certainly doesn't mean that this is the value of Ms. Mogensen's life or her child. But it will be the court's judgment in this case. So the court first, by law, has to consider probation, but it would clearly unduly depreciate the seriousness of these crimes if probation were granted. The court is ordering a state prison sentence here. The court is ordering restitution in the amount agreed to by the parties. That's in the amount of $12,599.81. The court is not imposing any fines because this is a significant prison sentence. The court does order you to pay all court costs, mandatory surcharges, and assessments. Those are the amounts required by state law. The Court directs the DOC to collect any monetary amounts ordered today at a rate to be determined by the DOC from Mr. Mosley's prison funds. Any monetary amounts that remain unpaid when Mr. Mosley is released from confinement are to be paid as a condition of extended supervision. Any monetary amounts that remain unpaid when the sentence is completed are ordered reduced to a judgment against Mr. Mosley for any unpaid balance, and collection can then proceed as provided by statute. Because of the nature of these offenses under Chapter 940, Mr. Mosley, you are not eligible for early release programming, including the challenge incarceration program and the substance abuse program, and the court so finds. There is some credit for time served. Mr. Payne, what is that number?
Judge, I have 57 days have not ran concurrent to his revocation. And have ran concurrent to revocation. We have 378 days.
Thank you. All right. Regarding extended supervision, the court leaves those conditions to the discretion of the Department of Corrections. The court does order a referral for mental health evaluation and also treatment as determined by the DOC. That is to be accomplished during the sentence. So with regard to the sentence, the court orders as follows. Now the PSI writer made a very significant recommendation. The state essentially adopted that recommendation with some changes. I agree that is the appropriate sentence here. And so the court is ordering as follows. As to count one, the court orders, this is consecutive to the current revocation, 20 years of initial confinement and 5 years of extended supervision. That is to be followed by count two, which is consecutive, 20 years of initial confinement and 5 years of extended supervision. Counts 3 and 4, which both also involve the death of Mrs. Mogensen. For counts 3 and 4, these counts are to be served concurrent with count 1. The court orders a total of 5 years of initial confinement and 5 years of extended supervision. That's on count 3. Concurrent with count 1. On count 4, the court orders 4 years of initial confinement and 4 years of extended supervision. Also concurrent with count 1, and those two counts relate to the death of Mrs. Mogensen. That is the court's sentence. Sir, the court is granting credit for 57 days time served, because again, this is consecutive to the current revocation. That would be applied to count 1. You have the right to appeal. Any notice of intent to pursue post-conviction relief must be filed with the clerk of this court within 20 days of sentencing. Your lawyer must continue to represent you until your decision to seek post-conviction relief or not is made. If you wish to seek that relief, your lawyer must file that notice within this 20-day time period. You receive a copy of this written explanation of the term that sentence. Parties, anything else for the record? Mr. Lonsky? No. Mr. Payne?
No, Judge.
All right. Now, I want to ask everyone to leave separately. I'm going to ask Mrs. Mogensen's family and supporters to leave first. Ask Mr. Mosley's family and supporters to remain. Mosley's family to remain just for another moment. We're going to keep everyone separate in the hallway.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa. We're the